Good morning and welcome to Racial Diversity in the Legal Profession. I'm Praveen Fernandez, the Associate Director of Programs at the American Constitution Society, otherwise known as ACS. For those of you who are unfamiliar with ACS, we're a national network of lawyers, academics, policymakers, and law students dedicated to advancing a progressive view of the Constitution, law, and public policy. On behalf of ACS, thank you for attending this morning's briefing and welcome. At the outset, I wanted to say that obviously diversity includes many categories: race, gender, sexual orientation, etc. This morning's conversation will focus on one part of that, one aspect, racial diversity. I have a small addendum to your bios. David Bernstein, professor of law at George Mason, called us this morning to say that he was ill, so he will not be at the briefing, and he sends his regrets. Okay, well, while our distinguished panelists will be introduced by our moderator, I have the pleasure of introducing our moderator, Michelle Roberts. A true recitation of her accomplishments and credentials would take more time than we have here, so I'm just going to give you the highlights. Michelle is a partner at Aiken Gump Strauss Hauerenfeld, where her practice focuses on complex civil and criminal white-collar defense. Before entering private practice, Michelle spent 8 years at the D.C. Public Defender's Office. She's a member of the adjunct faculty at the Harvard Law School. And in 2006, the Legal Times named her one of Washington's top 10 criminal defense lawyers. Thanks to all the panelists and Michelle.
Thank you. It's sweet. Good morning, everyone. Good morning. And I'm going to apologize because I'm going to start out by sharing some statistics, which are always popular. In the United States, 9.7% of the attorneys are minorities. That compares to 20.8% of accountants, 24.6% of doctors, and 18.2% of university teachers. Of that 9.7% minority, 3.9% are African Americans, 3.3% are Hispanics. The pace for blacks, African Americans, their growth in the profession has been slowing. The fastest growing group of minorities in the profession are Asians. There has been a drop in minority enrollment in law schools from 20.6% in the last 2 years to 20.3%. And there's been a drop for African Americans enrollment in law schools, 7.4% down to 6.6%. And then my last statistic, I promise, with respect to national law firms, only 4.4% of the partners in those law firms are African American. Those statistics I've taken from a report issued last year from the Commission on Racial and Ethnic Diversity in the Legal Profession of the American Bar Association. And those numbers, I would suggest, are a perfect backdrop for the conversation we're going to have this morning. A conversation which is going to center around essentially two things. One, do those numbers suggest that the profession is not adequately promoting full and equal participation of minorities? And if the answer to that question is yes, what can we do about it, and what should we do about it? Joining me in this conversation, or actually having the conversation, are 5 very interesting characters. And you've got bios. I'm not going to read the bios, but I will just briefly introduce them to you. To my right is John Nussbaumer. John is the Associate Dean of Thomas M. Cooley Law School, located in Michigan. Right? To John's right is Andrew Bruck. He's clearly younger than the rest of us. He is a third-year law student at Stanford, and he's co-president of an entity or a movement called Building a Better Legal Profession. You'll love hearing about this one. It's a movement started by some Stanford law students just last year?
This year.
Just this year. Great. All right. And to Andrew's right is Damon White. Damon White is in-house counsel at General Motors. He is actually the global litigation process leader, which must mean he's very important. And to Damon's right, last but not least, is Christine Sarkio. Christine is a partner at the second best law firm in the city, partner Howard and Simon LLP, and she's also vice president for external affairs for the Hispanic Bar Association. And I ask you to help me welcome each and every one of them. Let's start the conversation, John, by you're telling us a little bit about whether or not those numbers say anything about what can and should be done at law schools.
Thanks, Michelle, and good morning, everybody. Let me start by thanking you all for coming out this morning. I think this is a very important topic that is worth our time to discuss. My two main themes this morning are going to be first that law school admissions practices and accreditation practices that put too much reliance on the law school admissions test are shutting out qualified black applicants and other minority applicants from having the chance to prove through performance that their LSAT score is not an accurate predictor of their character and who they are as a person and their ability to succeed as lawyers. And second, my second theme is going to be that unless we address that problem, all the good work that you're going to hear other folks talk about in terms of trying to diversify corporations and diversify law firms is going to be frustrated by a lack of qualified black graduates at the end of the pipeline. Earlier this fall, I spoke at the Congressional Black Caucus's annual legislative conference at the request of Congresswoman Stephanie Tubbs Jones, who, along with Congressman Bobby Scott, has really made this an issue for the CBC. And there were some handouts that you may have that were actually the research findings that I presented at that conference, and I'm going to be following along those. I hope I won't bore you with some more statistics, but I think it's helpful to put this all in context. The handout that I distributed on page 2 charts African American law school enrollment. And basically what it shows is that African American enrollment peaked at the law schools approved by the ABA section of legal education in the 1995-96 academic year, and that black enrollment at those law schools has fallen short of that mark for the past 11 consecutive years. In other words, we peaked over 12 years ago, and things have declined since then. What's particularly disturbing to me is at the same time that decline was occurring, the ABA was actually approving 19 new law schools all across the country. Overall law school enrollment was growing at a fairly healthy rate of about 9%, and overall minority enrollment was growing by over 50%. So while everybody else was making gains, African Americans were falling behind. The second page, or the third page actually, of that handout charts African American graduates at ABA-approved schools, and not surprisingly, as enrollment has declined, graduates have declined as well, followed a similar pattern. The ABA actually stopped, the section of legal education actually stopped posting that data about 2 years ago, and I think the reason why is that it's a real problem. The next page charts what I've called shutout rates. I started looking at the data that the Law School Admissions Council posts publicly on their website. And basically what they do is by ethnic group, they show for each year how many applicants applied to law school, how many were actually accepted. And from that, I've computed what I've come to call shutout rates. What that chart shows is that over the past 5 years, 63% of all black applicants to ABA-approved law schools have been totally shut out from every law school they applied to. In other words, no matter how many applications they sent out, 63% never got a chance to prove through performance that they could succeed. That compares to about 49% of Hispanic and Latino applicants and just 35% of white applicants. In other words, about 2/3 of all black applicants never get in the front door. They never make it in the front door, even for the chance of a first year of law school to prove that they can succeed. Page 7 of that handout summarizes 2 law review articles, copies of which I think are available out front. The first one, both are from the St. John's Law Review. That actually St. John's University had a symposium on this issue in the fall of 2005. St. John's has something, the law school has something called the Ronald H. Brown Center for Civil Rights that is a great organization. And they put on a program all about the LSAT and the depressing effect it was having on minority enrollment. And the articles that I wrote were an outgrowth of that discussion. The first one basically looked at what law schools are doing in terms of their accreditation practices, or their admissions practices, excuse me. And I looked at the 8 largest U.S. law school markets, including the Washington, D.C. area. And the pattern was very consistent. Law schools were raising their LSAT scores, not because they thought they needed to make sure the students had a fair chance of success, but instead because they wanted to improve their competitive market advantage through the U.S. News and World Report rankings. If you don't know anything about U.S. News, they base their law school rankings, about 12% of the ranking is based on LSAT scores. About 15% is based on reputation, which unfortunately is heavily influenced by LSAT scores. I've actually seen promotional materials from other schools that on the front, all it says is 163, which is their median LSAT score. And those rankings are also influenced by selectivity in admissions, and all of that ties back to the LSAT. The second article took a look at schools that actually want to serve the minority and African American community. I looked at 20 schools that have 25th percentile LSAT scores below the national average. In other words, they're schools that are willing to take a risk on students, provide them with academic support, and give them a chance to succeed. And what that study showed is that over a 3-year period, all 20 of those schools were inspected by the ABA section of legal education. And all 20 of those schools raised their minimum LSAT requirements during that inspection period. 19 of the 20 saw the percentage of African Americans enrolled decline, and 13 of the 20 saw the absolute number decline by an average of about 19%. And I think what those studies demonstrate is that there's at least probable, I'm an old criminal procedure public defender, so there's at least probable cause to believe that those admissions practices and those accreditation practices are having a depressing effect on minority enrollment in general and African American enrollment in particular. That led the Congressional Black Caucus in June to call on Chairman Miller of the House Education Committee to fire up a GAO study, a Government Accounting Office study, of the section of legal education's accreditation practices and the relationship between those and minority enrollment. The relationship there is that the section really believes in the LSAT. They believe that the LSAT is I've heard them refer to it as the gold standard of law school admissions practices. And so they're not intentionally harming minority enrollment, but I think the unintended consequence of what their emphasis on LSAT scores is that schools are unwilling to take risks on those students, even when they provide a great deal of, put a lot of money into academic support programs and bar preparation programs to make sure those students have a chance to succeed.
Thank you, John. Andrew, what in the world is BBLP?
Building a Better Legal Profession. So we've gotten a fair bit of press recently, but let me just briefly explain to you what we've done over the last few months, and then talk about the impact that we're having at law schools in hopefully increasing minority rates at law firms. So what Building a Better Legal Profession did was, it started off with me and a friend of mine at Stanford, where we were exchanging emails with a professor over the summer, and I asked this professor, just out of curiosity, I've heard anecdotally that there are low minority rates at law firms. I was just wondering if you could send me a list from top to bottom, ranked all the firms in Manhattan by percentage of African Americans and Hispanics at the firms. And she went online and she looked around for those rankings, because I assumed that was something that was easy to find. And I went online and looked around, and I checked on Vault and American Lawyer and all these other companies that do these rankings. And we couldn't find anything, which seemed amazing to us. The best rankings we could find were the ones that Vault prepared. And if you know anything about Vault, first, most of the advertising space in the Vault guides are by firms. And so there's a strong incentive to only advertise the good firms. So if you look at the diversity rankings in Vault, they've got the top 10 firms. They don't tell you anyone below that. And the way they calculate the 10 firms is by a subjective standard where they send a guide or they send a survey to associates at a firm and they say, how diverse is your firm? Like on a scale of 1 to 10, and you circle 10. and then you get to be a diverse firm. And I wanted to know, what are the hard numbers? Like, how many African-American partners are there at a firm? And it turned out that this data didn't exist. What did exist was information that NALP, or the National Association of Law Placement, collects, which is they've got a website on nalpdirectory.com or .org or whatever it is, where they post online information about every firm in the country. And you can find out the number of African Americans and Hispanics, openly gay and lesbian, Asian Americans, females, the average number of billable hours that are worked, the pro bono participation rates. But the way that the site is organized is that each firm gets its own page, and the raw numbers are posted up there, and that's it. But the way that it's organized is there's no way to rank and compare firms. You don't get percentages. You don't know out of what total number those numbers are. So after emailing with this professor, and we realized that this list didn't exist, we said, well, let's just make one. So my friend and I, at the end of August, opened up an Excel spreadsheet. And it was literally this easy. I can't believe no one's done this before. We just went to each page of every firm in Manhattan with more than 100 attorneys in it, and we just typed in the numbers. Like, there are 2 black attorneys here, and there are 3 Hispanic attorneys there. And then, because it was an Excel spreadsheet, when we were done, we could just hit the sort button. And what's amazing is that we built a national movement based off of the fact that we clicked that sort button. What we found made our jaws drop. And I was here, actually in this room a month ago, giving a press conference about this information, when we found that 1/3 of all firms in Manhattan didn't have a single Hispanic partner, and that nearly 1/3 of all firms in Manhattan didn't have a single black partner. And this is 2007. African Americans and Hispanics have been going to law schools for a long time. They've been graduating. They're coming in as associates, and then they weren't sticking around by the time they were a partner. We're seeing the same thing for women at even higher attrition rates. We're seeing similar things for Asian Americans and for openly gay and lesbian attorneys. And we were amazed by this. And so we decided, let's publicize it. And then we were in the Los Angeles Times, and we were in the New York Times. The day after our press conference, 10,000 people visited our website. The day that we were in the New York Times, 2 weeks later, 100,000 people visited our website. And that's both law students and law firms. And what I've been told, what I was told from Adam Liptak in the New York Times, was that basically the firms at the bottom, an attorney would get our website and would then send out an email to everyone in the firm with the subject header of, like, expletive. What are we doing at the bottom? And I don't think a lot of firms realized this, or they had known it anecdotally, but then once they could compare it to their peers, they realized that they were at the very bottom and just how appalling the numbers were. But what's really interesting is the reaction among students, because my generation has grown up during a period of affirmative action. That's all that we've known. And so I went to a college that was very diverse, and I went to a law school that was very diverse, and we expect our employers to be equally diverse. And so when we look out at this profession and we see that there are such low minority rates, it's appalling, and it's really disappointing. And the analogy that I use is summer associates at firms. If you've ever encountered a law firm and you know anything about their summer associate programs, it's a little bit ridiculous. You make about $3,200 a week. But the thing that's really crazy about it is that if a firm has 70 summer associates, all 70 of the students get offers. Unless, like, the rare example where, like, the girl takes off her clothes and throws herself into the Hudson River, and, like, then they get a cold offer. Depends on the firm, and, like, yeah, then it's a cold offer or something. And the reason I bring that up is not to point out how ridiculous the system is and how broken the economic model of firms are, but to point out that the reason why a firm will give all 70 of their summers an offer is because no one wants to be known back on campus as the firm that didn't give anyone an offer. Because everyone else is doing it, and if they're the firm that didn't give an offer, then people won't interview with them next year. Because I could go to any of the top 100 law firms in the country and make truly an absurd amount. I could make $160,000 at any single one of those firms during my first year. And like with all due respect to these like very good law firms, you'd be doing roughly similar work, and what differentiates it is maybe your client base and maybe the number of billable hours that you'd be working, and probably your Vault prestige ranking. And just as firms don't want to be known as the place that doesn't give offers to their summers, we're also, or our plan was, and we're finding this is true, that firms don't want to be known as the place that doesn't have any black partners, or the place that doesn't have any openly gay associates. And what we're doing is using the market power of students to change the way that recruitment works. So I just flew in here from USC, where I gave a similar presentation to a packed auditorium full of students, where I just put up the rankings on a projector and said, here are the firms at the top, here are the firms at the bottom. I have no idea why these X firms have no black and no Hispanic attorneys. But judge for yourself. And when you're choosing between firms that look basically the same, all things being equal, take this into account. And as students begin making choices based on this information, because this is actually something that matters to them, the firms that aren't at the top of the list have got to work extra hard in order to attract the top recruits. And so what we're doing is creating a market power and a market force through, in a sense, a form of collective organization to change the way recruitment and hopefully the way law firms work. And the response that we've gotten is overwhelming. I think probably every law firm in the country knows about what we're doing. I've heard that there are firms at the bottom of the list that have had strategy sessions of what are they going to do when they come to campus next year for on-campus interviewing. And they have to explain why they're the firm that doesn't have any black partners. And that puts the burden on the firm rather than the student to ask that very, very important question. And I've had friends come up to me, and notably the white guy from Scarsdale, who said that he crossed firms off his list that he was considering because it had low minority rates. This is something that matters to everyone, and it matters to folks in my generation. And I am just one of the many people who are part of a movement to hopefully change what the next class of young associates will be.
In 1999, you weren't born
I'm
yet, Andy.
Yeah.
A group of in-house counsel issued a statement of principle, and I'm just going to read 2-3 lines from it. We believe that promoting diversity is essential to the success of our respective businesses. It is also the right thing to do. We expect the law firms which represent our companies to work actively to promote diversity within their workplace. In making our respective decisions concerning selection of outside counsel, we will give significant weight to a firm's commitment and progress in this area. And in 2004, that statement of principle was reaffirmed. Did your company sign on to that statement of principle, Damon?
We did. We absolutely
Let's
did.
check it.
Call to action, as it's otherwise known. And I want to thank everyone for having GM here. We've been very active, I think, in the whole diversity of the legal profession for a long time. And I'll make a few comments about what the legal staff is doing at GM on this issue. But to put it in perspective, let me give you a little bit of background. First about myself, just 1 minute, not even. I spent 5 years practicing at a firm before joining GM. I was at a large firm in Minnesota, and it's interesting to hear Andrew say that now students are asking, or non-minority students are asking about minority representation at firms in the interviewing process, because when I was interviewing back in 90, it was I went to Howard, and we always ask, thank you, and incidentally, Howard is the fourth oldest law school in the country. Excellent. We were always the ones asking, well, how many African-American partners, that sort of thing. And at that time, that was going out on a limb to ask those kinds of questions. And we fully expected not to get callbacks when we asked those questions, but we felt that we should because we were going to be entering into a system, and we needed to make sure that we were at least getting to the best place that we could. So I applaud that. And then I've spent 10 years at GM and just completed my 10th year there. And so I started practicing in the early 90s, so I've seen about a lot of things, probably not as much as some others. But I've been in a situation where my name's gone down on RFPs and I've never touched the file. I've been called different things in court by judges and by partners and different things like that, and I think a lot of that has gone away. But there's some other things that are occurring. A little bit about GM. Hopefully you all know that we are a global company. We operate in 200 countries throughout the world. We sell the most automobiles in the world. Currently, Toyota's right behind us, but we're still number one, which is interesting because we operate in 200 countries. We have over 200,000 employees. They speak more than 22, way more than 22 languages. We have 22 unions throughout GM. We have a fair amount of all kinds of people at GM. So diversity for us, it's not an issue, it's the way of life. We cannot operate without diversity. For the legal staff, well, let me go back to the corporation. For the corporation, diversity is a goal for the corporation, just as is quality, efficiency, integrity. Diversity is one of the corporate goals, which means that for the legal staff, it's also a corporate goal. It's a legal staff goal. And for the legal staff, we fully believe that it's a business imperative that the lawyers representing GM, in-house and outside, in order to provide the best quality representation, must be diverse. We must be able to choose from a broad pool of lawyers in order to represent General Motors. And it only makes sense. We're in 200 countries around the world. In this country, we probably have a matter going in almost every courtroom in almost every state. We're in a lot of boardrooms. We're in a lot of conference rooms. So we see a lot of different people. I myself do litigation, and typically a lot of the juries that we encounter look much like this room. People of all kinds, from all different backgrounds. So for the legal staff, diversity is just a business imperative, which means two things for us. Diversity is a metric that's linked to the overall compensation for senior leaders on the legal staff. That's important. That means diversity is important. It means that people are measured. And in the corporate world, we always say, what's measured gets done. The other thing is that diversity is a critical success link for any outside counsel that wants to initiate, maintain, or expand their business with the legal staff. That is key because, again, the goal is to provide the best quality representation to our client, General Motors, and we can only do that if we can choose from the best lawyers out there. This is not a new initiative for GM legal staff. We started this back in 1988 with a simple letter. Our then General Counsel, Harry Pierce, who's from North Dakota, I think Boise. No, someplace in, I don't know, someplace in North Dakota. Been there once. And that's Idaho. What am I talking about? Boise is Idaho. Right. That's not mine. Right. I forgot where he's from. He'll kill me if I don't remember. He sent out a letter to all outside counsel, a couple paragraphs that just said, please identify all of the minority and female attorneys that are working on GM matters. At that time, we probably had over 1,000 firms working for GM. And I won't make you guess, but I think we got one response out of all those firms, one response. And so from that point forward, we just sort of set out to work on the issue. So in between then and now, we've done a lot of things, but I'll just tell you sort of the latest thing, sort of where we are now, and then work a little bit backwards. In 2005, what we did was we sent out a letter, again, from our North American General Counsel, who's African American, and the what we call the Executive General Counsel of GM, sent out a letter in 2003 to our top 100 firms, which make up most of our billings. And it was pretty much a simple letter, and it just said, by the end of 2005, we'd like to see the people working on our files from your firms match our internal demographics at the legal staff. Simple enough. And that was, at that time, we had 20% minority lawyers on the GM legal staff and 33% female lawyers. And we just said at the end of 2005, we expect that the teams working on our matters pretty much match that. And as you could expect, it caused a huge stir. Suddenly, we had all these firms and lawyers flying up to Detroit. Almost nobody comes to Detroit, asking us, what could they do? How could they do this? And what did this mean? If we don't match it, do we lose business? Do we, do you fire us? What happens? And at the time, it really just was a goal. And we hadn't thought about any punitive type action or anything because it's really just a goal. Sort of simultaneous with that, maybe a year or two before, we put in a number of systems in place to help firms sort of get there. We put in elaborate systems, billing systems in place so that we could count who was working on our files. So if you work on our files, any lawyers here, if you work on our files, in order to get paid, you have to tell us your name. You have to tell us what year you graduated from law school, whether you're a partner, associate, and then you have to tell us what your ethnic background is and whether you're male or female, which restroom you use. And then that way, we can keep track for ourselves. Not that we don't think firms would be honest with us, but we would like to keep track of who's working for us and who we're paying. And so we did that, and we started sending out these little report cards to firms and say, by the way, 2% of the billings on your files were Hispanic. What are you going to do about it? The overwhelming response to that from firms was very positive. People came in. They said, what can we do? We have been, GM internally, we've been on this diversity track for a while. So we had a lot of ideas, but we are in no way the expert, especially when it comes to law firms. We're in-house. A lot of our lawyers were from large firms, but a lot of our lawyers grew up at GM. So we really did leave it up to the firms to sort of figure it out. Where are we today? Overall, 16.1% of the lawyers that work on our files outside are minority, and 28.6% are female. So from 88, when we got one response out of 1,000 firms, to 2006, we've made, I think, quite a bit of headway. Some of the things that we're now doing, just to close, is we've now taken that sort of a step further. We certainly can count the number of lawyers we have. I think we have sort of filled the pipeline. Now the issue for us is the Bet Your Company matters, those kinds of matters, those kinds of deals, the huge Delphi spinoffs. Who works on those? Well, pretty much the same groups tend to work on those. So now, while we have the pipeline filled, I think we have a number of attorneys that work for us in a very broad category. Now we're headed towards sort of diversifying our top ranks, those top 10 lawyers in the country and the world that represent us. And to do that, we've instituted a number of programs. We've instituted a joint mentoring program with the firms. We've invited some of our top firms to come in. And we've just said, some of our top lawyers are aging. And so to make sure that we have a continuation, we said, well, point out the stars in your firm. Point to the stars. They don't have to be minority. They don't have to be female. Just tell us who the stars are. But give us a group. Don't give us one or two people, because we know how that goes. Lawyers tend to move around firms, and some go in-house, and some go government, some go to the White House. So we said, just give us a group. And what we'd like to do is take that group, and we'd like to jointly mentor that group. We'd like to introduce them to our company, get them to know our business over a period of time, and hopefully out of that group will emerge some rising stars that everyone can agree on as a rising star. The only requirement we have for that group is if it can be a diverse group, it should be a diverse group. Absolutely. We started that program this year. We've completed our meetings with those firms. And I will tell you, the top firms that came, that we invited, they gave us a diverse group of people. And these are not people that they went out and got from other firms. These were people that were existing in their firms, that were already there. But I think the significant thing is, unless we asked, unless we requested this, I believe that we would have gotten not such a diverse group of people. I believe we would have gotten the same 2 or 3 people that we generally get. Because let's face it, our profession is based on relationships. It's the end of the story. It's subjective and it's based on relationships. So if the top lawyer that handles our top matters, he is going to present who? His lieutenant. And whoever that person is who he will or she will present. So all we did was say, in addition to that person, broaden the group, go throughout the firm, and find some other top candidates, and let us take a look, and let's everyone compete. So that's sort of where we are today. There's some other things that we do, but I don't want to take too much time, but I think that's the highlight of our program.
Christina, when a firm like GM says to a law firm, fix it, what's a firm to do?
They're going to try. Good morning, everybody. I am not here today to paint a rosy picture of diversity at law firms. I think there are a number of law firms that are doing some very innovative and creative things to promote diversity internally, but I haven't seen any firm that is doing it well. And I'm gonna leave aside here minority and women-owned firms, because I think by definition they're doing a good job. But in terms of the majority-owned major law firms, like I said, I've come across some very creative programs. People are trying, but nobody has it done. Nobody has it right. Michelle talked about a statement of principle, and for a long time, diversity has been the right thing to do. But let's be real: law firms are businesses, and when times are tough, the right things to do, like pro bono, like community service, like diversity, go by the wayside. It's too complicated. It takes too much money and time and effort to pursue it. So you know what? We're just not going to focus on it this year. We'll look at it next year when we've got more money and we're more successful. And a statement of principle, what it did is all of a sudden firms perked up. And they said, Now what they had been doing up to that point is they'd been going to the top law schools, top 10 law schools, getting the top 10% of the law students and recruiting those folks. And if one of those folks happened to be an attorney of color, fabulous. But that's all they would do. And so when the statement of principle came out, they looked internally and they said, hey, we got a couple of attorneys of color here. Let's put them on the pitches. Let's put them on their names on RFPs. Let's promote them. Let's make them more visible internally. And it started to work a little bit. It made a little bit of a dent, but not much. And then a few years after that, Rick Palmore, the general counsel of Sara Lee, issued a call to action. And a call to action now had more teeth than a statement of principle. A call to action basically said, it's not enough that you're going to diversify, that we want your firms to reflect either our legal departments or, frankly, the community at large. We're now going to penalize you, in fact, if you don't meet our standards. Now firms really started perking up. We got to do more than just go to the top 10% schools and get the top 10% students, because frankly our numbers aren't good enough. And so that is really what changed the dynamic at law firms and started making law firms do more creative things. I don't have very many statistics. I think the only statistic I have is a NALP statistic that says today in 2007, I think it's 78% of law firms have a diversity plan, which is a step in the right direction. It's still surprising to me that not everybody has this, but 78% I guess is we're on the right path. And so what firms start off with is with a diversity plan. All right, we know our numbers aren't good. Let's figure out how we can improve it. Let's bring in a consultant. There are a number of diversity consultants out there, some better than others, but there's an industry that is helping law firms do this. They turn to diversity consultants. They look internally. Some of them hire diversity managers, either lawyers within the firm that know the culture of the firm and that can step into that role, or they bring somebody in from the outside to serve as sort of the chief diversity officer or chief diversity manager to focus on promoting diversity. And where we're talking about diversity, it's not just limited to race. Obviously, it's limited to sexual orientation, to women and other disabled attorneys and other considerations. And so they've got a plan, and they've got maybe somebody in charge of that plan and responsible to execute it. It's amazing to me how many firms stop there. We've done what we need to do. They'll take care of it. We don't have to worry about it. But you need to go further than that. And fortunately now, more firms are doing more than that. They realize they've got to be more aggressive in recruiting beyond the top 10 schools, especially now since law school enrollment overall is down. And so they've got to look beyond sort of their standard go-to places. Fortunately, there are a number of organizations, the Hispanic National Bar Association, the National Bar Association, that offer minority job fairs. And so law firms now don't just have to go on campus, but there are other avenues for them to recruit students of color. I've also seen some law firms do internship programs with local school. In Washington, D.C., we've got some fabulous law schools in the area, Howard being one of them. And so a lot of law firms have either fellowships or internships, and so students will work for them during the year. And so it's not just limited to a summer associate program. They have an opportunity to get to know students and introduce them to the firm culture, and hopefully that student, once they graduate, will become an associate and will go down the garden path towards partnership. And so those are things that are helping in the recruiting process. Again, I see a lot of firms that stop there. We've got somebody in charge. We've got a plan for recruiting. What else do we need to do? Now the focus is on retention, developing young lawyers. Mentorship programs, in my experience, and I'm speaking just for myself, I haven't seen them to be very effective. I have never had a mentor, and looking up, I've never encountered a Hispanic female that that frankly, there are just not that many in law firms and in the legal profession that I can look to and try to get a mentor from there. And so I look to different people to help bring me along. But those are relationships that have evolved informally and naturally. I have found that formal mentorship programs just don't work. They're very they're forced. People are not comfortable. They may not have common interests. They'll meet a couple of times and then that ends that. But I certainly would not suggest that people should give up on that. I think it's important to have it. I think it's certainly important when a young associate comes in through the door to have an assigned mentor, someone that at least they may hit it off with. Usually not, but every now and then it works. And so I would encourage law firms to continue with formal mentorship programs. But what I've seen that works better is when law firms provide opportunities for informal mentoring. Law firm retreats, get-togethers, affinity groups are great ways for people just to come together naturally and to develop a relationship, and they can help each other internally within the firm. In terms of other types of grooming of the young associates and grooming young lawyers, a lot of firms are doing these professional development programs. We have them at Howard, where we have professional development workshops. We bring in guest speakers. They're sponsored by the Diversity Committee. We bring in guest speakers prominent attorneys of color that can speak on this issue or that issue. And it's very invigorating to young lawyers to see these folks up here, talking about their successes and their path and what they've done, and they can model themselves after those individuals. And so people have found that to be very rewarding. Similar with, workshops, how to get business, how to be a better writer, how to be better in court. The issue there, though, is, and I can speak just from what we do at Harry, is a number of attorneys of color or associates of color feel that they don't want it to make it seem like they need any special treatment. And so what we've done to get away from that is we will invite the law firm, it's open to everybody in the law firm, but it's sponsored by the Diversity Committee. So the Diversity Committee is sponsoring a seminar on business development. It's open to everybody. Now, usually, it's the attorneys of color attend, and every now and then you get other folks that attend too. But at least they feel that something is being done for them, but not necessarily singling them out. And that has been very effective because people are sensitive that they don't want to be isolated or singled out or treated any differently than a lot of their colleagues. I've also seen law firms that bring in marketing people to help attorneys of color market themselves, find speaking opportunities for them. At the Hispanic National Bar Association, we have an annual convention. We have CLEs, and the CLEs are not just about Hispanic issues, but they're about IP issues or antitrust issues. And so it's a great opportunity to find attorneys of color that can speak to those issues. And the same thing with the National Bar Association and the NAPABA as well. One of the things I've seen one law firm do, and I'm certainly not shy about plugging them, is Holland and Knight. They have this Rising Stars program. I've been very impressed with the program. It started off for women, and I think they're expanding it to attorneys of color. But what they'll do is they'll take a senior associate, and they'll start grooming that associate for partnership and for leadership positions within the firm. And so that associate is, I think they pick maybe 2 or 3 every year, is invited to executive committee meetings, is part of the sort of the strategic planning, is included. And it's an opportunity for this young person to get a feel for how to manage a law firm, how to be successful, how to lead a law firm. And I think that's a wonderful type of program, and I would encourage other law firms to adopt similar types of models. In terms of the metrics, I have to say that I applaud Andrew and Stanford's efforts, because for a long time the carrot has been getting more business from Damon, from GM, and companies like GM. Hey, if we promote attorneys of color, if we show that these are folks that are working on their matters, we're going to get more business from them. And so that's been an incentive to diversify the lawyers at a firm. What I've often asked some of my colleagues in-house is, well, it's great that you do this, but where's the stick? I mean, are you firing anybody who's not satisfying your standards? And few companies, there have been some examples, and they've been very public, but by and large, companies are reluctant to do that. These are, they have relationships with law firms that have expanded, over 20 years, and so they're not willing to pull the trigger and cut them off just because they don't have any attorneys of color. And frankly, that might raise some liability issues as well. But in terms of the metrics, I mean, law firms, and Andrew, you're right. I mean, there's not much to distinguish one law firm from another. The work is generally the same. There's a different client base, and there are perhaps different specialties, but law students can go, especially law students at the top schools, can go to a number of different law firms and do very similar kind of work.
For the record, I disagree.
And this is, again, it's a disclaimer that I'm speaking on my behalf, and I'm not speaking on behalf of Harry, but it's just, this is a stick here that I think law firms have not, until now, never really thought about. They might get those questions at interviews, and sometimes, we do a better job of preparing some lawyers than others for these types of questions in terms of law firm life, work balance, work-life balance, diversity at law firms. And so by having these numbers out there, that sets firms into a panic. I mean, there's nothing they love more than rankings. You go to every website, we are #1 here, we're #2 there. And it's amazing to me the things that we do. You know, at the Hispanic National Bar Association, we honor every year a law firm that's done great in terms of diversity. And we don't really talk about how great they do. We talk about the fact that they've done great. What does that mean? Hey, they had no Hispanic lawyers last year, and they got one this year. Let's give them an award. You know, and it's, I mean, you scratch the surface there, and there are a number of organizations that are doing that. It's great visibility. They're doing a great job, but when you really scratch the surface, it's pathetic. And so these kinds of numbers, yikes! You know, law firms are saying, uh-oh, we got to do something about it, because it's not just the law students. It's companies are looking at this stuff too. I mean, this is very public. I think this, everybody went into a frenzy when these numbers came out. Fortunately, Harry did pretty well there. Yes. But, it's exactly the kind of thing. I think law firms were not prepared for it. And it's another kick in the rear in terms of get going, people. You need to do something about the problem here that you have. And the world is changing. And if you're not going to change with it, you're going to be left behind. And this all does go to the bottom line, which is why law firms are motivated now to really change the dynamic and implement some creative measures to try to diversify the talent pool.
Andrew's jaw dropped when he looked at the numbers of partners, minorities at the partnership level. There's a chap that teaches at the University of California School of Law named Richard Sander, Professor Sander. He wrote an article titled "The Racial Paradox of the Corporate Law Firm." And his explanation, and it's a very long article, so I'm going to give you a very brief version, but his explanation for why there's so few lawyers of color at the partnership level is because we begin, he says, by admitting into top law schools students who can compete. And we then, we begin at the undergraduate level, affirmative action, admitting students who really don't belong there into the undergraduate school. We repeat that mistake by admitting students into top law schools that really don't belong there. And then law firms compound it, because they're concerned about GM and companies like GM, by hiring lawyers who really can compete. Therefore, they don't make it to the partnership level. Is that about right, John?
Let me talk about the law school context, because that's what I'm most familiar with. At my school, at the lowest LSAT range that we admit students, about 77% succeed academically. And on the bar exam, in that same group, about 86% eventually pass the bar. Now, there's some fallout there. When you admit students who have lower LSAT, sometimes the LSAT is an accurate predictor. But what we've found over the years is that the LSAT does not measure every quality that's important to being a lawyer. And that if you do give students an opportunity and you do provide them with the kinds of academic enrichment and support programs that are helpful, many of those students, we look at 77% and say that's a pretty good batting average. And we actually tell our students in advance in our acceptance letters, we tell them what their chances of success are. So at least from the law school perspective, there are lots of qualified students who, despite their LSAT score, I mean, I can tell you lots of anecdotal stories of students with 137 LSAT scores, which is about the 10th percentile in the country, who graduate with honors, are on our law review, are now district attorneys or good lawyers. So the idea that black applicants and other applicants can't compete and that we're doing them harm through giving them the chance to compete, it really reminds me of if you look at the Reconstruction era following the Civil War, there were a lot of folks who said, well, we shouldn't let freed slaves become lawyers for their own good because they can't compete. And it's basically the same argument that was made over 100 years ago. So at least from our perspective as a law school, we don't see that. We do see students who fail because when you take risks on lower LSA students, that's part of the bargain. but we see many more who succeed and are going out and becoming lawyers, not only at the big firms. We've talked a lot about big firms. Michelle and I were public defenders. Somebody needs to represent the little people of the world, the blue-collar folks of the world who have legal problems, serious legal problems, and right now aren't getting served because as big as the law profession is, there aren't enough lawyers to represent those folks.
Christina made reference to potential liability. If a company were to dismiss a law firm solely because the company was displeased with their numbers, another chap named Kurt Levy wrote an article, which is too long to read to you, and I'm not going to, but titled "The Legal Implications of Complying with Race and Gender-Based Client Preferences," essentially suggesting that a law firm that, in response to a firm like GM, does diversify its legal team, but that law firm may be violating the Constitution, specifically Title VII and Section 1981. Damon, are you encouraging constitutional violations?
Certainly hope not. I don't believe that we are. And I know what the call to action says, and I'll tell you how sort of we deal with the issue of firms that may not comply with our request. And let me start out by saying we have not encountered a firm that has just told us no. I mean, it has not happened. The 10 years I've been involved with this at GM and more years for others, it just hasn't happened. What we do is we work with firms to encourage them to meet our goals and to meet our request. We have written into contracts or retainer agreements with firms that if our goals are not met, they will suffer a financial penalty. Absolutely we have. So we work with them to develop the goals. We don't just say, you must do this. We meet with the firms and we say, here's our goals, sort of here's where you are. Let's work together and see what makes sense for your firm at the time, and let it be a progressive thing. And if you say you're going to do something and then you don't do it, well, I'm not sure how many businesses operate with just saying, oh, no problem. Well, we're a business, and we're purchasing a service, and so if you say that you're going to do something and you don't do it, we must take action. And so, yes, we have written into retainer agreements financial penalties for not meeting our goals, and I think that's perfectly acceptable. I don't think that we are forcing people to violate any laws. And again, what we're simply asking is that we get to choose from the best pool of candidates. In some respect, in some instances, that will be Andrew. And then sometimes, it's going to be Christina, and sometimes it's going to be you, Michelle. But the point of it is if we only have Andrew to choose from, how do we know we're getting the best pool? And so I think from that respect, and I know I didn't answer the question, I'm not a Title VII lawyer, but from that perspective, I don't think that that's what we're doing.
I am told that I must give you guys an opportunity to ask questions. So I'm going to do that, and I'm also told that I have to begin with the press, since we're at the press club. So I'll initially invite any members of the press who are here to start out. We have a microphone somewhere. There we go.
Peggy Ochowski, sorry. I'm with the Hispanic Outlook magazine for higher education. A couple of things. How do you, it seems to me, it sounds like what's happening in journalism, that they want a lot of diversity, but it turns out all the diversity is from the Harvards and the Yales and the big schools. And I don't know outside of the law school how you get the hirers, the employers to hire people who come from the less known law schools who are coming out of community colleges. And in that sense, I'm one of these Zoomers the boomers who are not going to retire, and I have a lot of friends, and it's the tip of the iceberg, who are going to these law schools, the night law schools, want to have a 10-year career as a lawyer. How are they going to get hired? They're in their 60s, you know. So how do you get employers? In the end, it isn't at the schools. You know, the schools get a lot of money, and we're going to be diverse. How do you get the people to hire them?
I mean, we do a number of different things. I think I mentioned that organizations do minority job fairs, and so there's a way for law firms and companies to go and interview folks, and those job fairs they're typically split so that the employer perhaps selects 5 resumes, and then the organization just assigns them 5 others, and so they have to look at a broader pool of applicants than they normally would, and so that's become a very popular avenue of hiring people. Other ways we do it is sometimes we recommend that, especially folks' grades, even if they're at the top schools but their grades aren't great, you know, go do something else for a couple of years. You know, perhaps try to, and certainly not to diminish any of these other professions or choices, but you know, if you want to try to do a clerkship or work for the government or work for a nonprofit, get your feet wet in other types of ways, and then apply later. You don't have to come out right out of law school. You know, we're always looking for lateral candidates as well, and so don't give up just because your grades aren't great and you get rejected right out of the gate. Keep trying.
Hi, I'm Peter Schmidt from the Chronicle of Higher Education. I'm loud enough. I'm glad there are a couple of Michigan people in the room because I covered Proposal 2 last fall, and I'm wondering how that has changed the landscape in Michigan in terms of diversifying the legal profession there, whether you think the University of Michigan Law School and others, law firms that care about this issue, are finding alternative ways to diversify the profession there. And what happened there evokes a bigger question to me, which is whether there are political dangers from taking steps that might prove unpopular out there. You know, if it's not just constitutional issues you have to worry about, but popular perceptions, voters, things like that, and whether there's any discussion of trying to find diversification mechanisms that may not face as much of a backlash as some things like race-conscious admissions have.
You're looking at me. Let me start by describing what my school does and then what I think the other schools in Michigan are doing. My school, actually, we don't engage in affirmative action. We have race-blind admissions policies. We set our LSAT numbers at a level where we think students have a reasonable chance of success, and then we admit those students, assuming they meet our qualifications. So, and we've managed, we now enroll more minority students than anybody in the country. We're also the largest law school in the country, but we've managed to do that without engaging in race-based admissions policies. I think what's happening with the other law schools is that they are finding other non-race-based ways to identify students who grew up in underserved or underadvantaged communities. So instead of doing it based on race, they may do it based on economic background, which gets you out of the race issue, at least directly, and gets you into a more across-the-board open policy that looks not just at race but at those other factors, because we also admit a lot of Caucasian students whose LSAT was not wouldn't get into Stanford or wouldn't get into other schools, and we think there's an advantage there. We think they're part of a sort of a working class community that's probably underrepresented in the legal profession as well. So there are ways to do this that are not race-based, and there are other ways to do it that take race out of the equation directly, at least, and look at other factors.
Hi, Alex Meneses with Hispanic Link. A question for Mr. Brock. On your project, have you been able to quantify in any way how effective the project has been? And if so, is there a way to get those numbers?
Well, it sort of, we'll be able to get a sense, well, there's a couple different ways you measure our success. The first is just in getting our message out there. The more that firms are aware of what we're doing, the more that we increase the salience of the issue. And the more that the issue is salient, the more that they're going to take the steps that were discussed to make their firms more diverse. One thing that I didn't mention that sort of is our next step is we're taking our rankings and we're printing them up in PDF versions and we're sending them to every Fortune 500 company in the country, and encourage them to consider this as well when they're making choices to do the kinds of things that GM is doing. And so a lot of the effects of what we're doing are going to be more diffuse than it might be immediately apparent. You'll start to see the first indications in the next few weeks when students are deciding where they want to spend their summer. I think December 15th is the deadline. But we don't expect this to happen overnight. It's a long process. And I think that all you need is a couple students on the margins to make decisions based on this, and that's enough to scare firms into realizing that they have a financial incentive to do something about this problem, in the same way that their clients, like GM taking actions, provides a financial incentive to them for them to do something about these problems.
Morgan, and I actually work for ACS. And as a person who will be applying to law school soon, my question is, you talked a lot about how, what the stick is for these large law firms to have a more diverse population. But you put it in terms of sort of all things being equal, people who are 2Ls looking for, some social positions say, I would really like to work in a place that has better diversity. What is sort of the stick then for law schools to admit a more diverse population? Because the all things being equal argument doesn't really work, because it's more like, I'll go the best place I get in, and the place that gives me more money, and there are all sorts of things that matter more to people, it seems, I'll say, than I would like a more diverse student population. So what's the stick there? If you guys could.
I feel like I'm the designated hitter for a lot of these. Let me say this. Unfortunately, the stick right now is in the other direction. The stick is if a school wants to serve lower LSAT students, they face a difficult battle with the ABA accreditation apparatus. And we've actually fought that fight for 30 years, and it has never gone away. So that's I think that's one of the problems right now, is that schools who want to serve those communities aren't free to do so. They aren't free to admit the students they want to admit, even when they do make an appropriate investment in academic support programs, so that it's not just a sink or swim kind of operation. And I think that's one of the things that needs to change. I think that the GAO study that Congresswoman Tubbs-Jones and Representative Scott have asked for, I think would help that. Because what we've got to do is focus attention on the blockage in the pipeline at the front door. With other schools, unfortunately, if you're a dean and your U.S. News and World Report ranking goes down, you face the very realistic prospect that you're going to be out of a job. And that's a very difficult thing to address because it's systemic. It's not just one school or two schools. It's a pressure that all schools feel. So I don't have a good answer for that one. But on the accreditation side, it would help very much if schools were allowed to develop programs that serve those communities, as long as they do offer the kinds of academic support programs that are necessary to help overcome a K through 12 education that maybe wasn't as good as the next person.
Excuse me, are you saying that your accreditation ranking is based on the level of your LSAT scores of your students?
We are required, every law school in America is required to report on their LSAT scores. their median and their 25th percentile and their 75th percentile. That's part of the annual reporting process that the accreditation committee requires schools to go through. And I can tell you from experience that if you admit too many low LSAT students, you become, that's a red flag that puts you under the accreditation microscope.
That is if they don't pass the bar at the other end.
That's what I was going to say, what about the other end?
Right, and that's why you have to look at both of those criteria. Yes, every school is required to report their bar passage rates, although right now it's only first-time bar passage rates, which is a problem because, I can give you a quick, there's a New York study, New York State Board of Law Examiners did a study that was released this past summer. They followed 10,000 graduates on the New York bar exam who took the exam for the first time in July of 2005. And then for the ones who failed that exam, they looked at what they did on the next two exams. So they looked at a spread of 3 bar exams. And what they found is that while African American takers didn't do so well on first-time pass rate, by the time that third exam rolled around, they had an 83% pass rate, looking at the group that started in July 2005. And one of the keys to that is I think schools have an obligation to develop academic support programs at the back end that actually help prepare students for the bar exam. And that should be something that is, I would say, is required of schools who want to admit students with those lower LSAT credentials.
Hi, I have a question with respect to diversity. I worked in a firm for 5.5 years, and I found that a lot of efforts were made with respect to diversity recruiting, but not as much to retention. And I applaud Mr. Bruck's efforts gathering the numbers, but I've also been at a firm where they just bring in some lateral partners, and everybody's not homegrown, and there's not as much attention given to professional development. So I have 2 questions. One, how do you measure the effectiveness of diversity recruiting or diversity requests, as Mr. White does? And 2, what are some of your ideas with respect to diversity or minority associate retention? I just think a lot of times a chance isn't enough. Sometimes you need to make sure that people don't fall through the cracks during the process.
You know, and I'll start an answer. We did recognize that at GM because what we were finding was at some firms it was a revolving door. The numbers, you know, were the numbers, but the people were different every 2 or 3 years, which is
They all look alike.
yeah, right. Yeah, which I will tell you from an in-house perspective is a problem. I mean, it's a quality problem and an efficiency problem for us, because what tends to happen is if every 3 years I have to deal with new outside counsel, I have to spend time training them, getting up to speed. You know, these are our products. This is how we develop them, etc. So one of the things that we did in our program, in our systems, was we started asking for the year they graduated. And we are paying particular attention now to not just numbers, but to people. So if you started in 2005 and 2010, is this person still with us? Are they still billing on our files? And if so, what are they doing? Are they still writing briefs? Are they taking DEPs? Are they trying cases? And to the extent that they seem to be running in place, then we will address that. Because again, it is an efficiency and quality issue for us. If you are doing the same thing for us for 5 years, that means someone is being really inefficient, either the law firm or us. And I will say it's probably both. I am paying more 5 years from the day that person starts to do the same exact thing they started doing on day 1. That's inefficient, and that's just not good management. And for the firm, it's a problem. And so that's one of the things that we're doing to that issue. And then the other, in terms of retention, is, and again, it's a little bit of the carrot thing, is what we're saying is, you know, with our mentoring program, you have the opportunity to continue your firm's business with us. And Christina, is right. Some of the firms we have relationships with 30, 40, and in some cases 60 years. And that's not a problem. That doesn't mean that will always continue, and it doesn't mean that there's not work for other firms, new firms. But I think the mindset today is because you have a 60-year relationship doesn't mean it will become a 65-year relationship. So the carrot again in terms of retention is here's an opportunity. We've developed this mentoring program, and hopefully all things being equal, everybody sort of can compete in it, and let's see who wins. And it might be the firm with the 30-year relationship, or it might be the firm with the 2-year relationship.
Also, just as a quick addendum, one of my favorite statistics that we produce is what we call the opportunity gap, where what we do is we look at the percentage of minority associates and then compare that to the percentage of minority partners. It's a little bit easier for women because there's a sharper drop-off. But you'll see some firms where they'll start off with 40% female associates and then 20% female partners. You can see it's a 50% drop. There are other firms where it's 60% female associates, 10% female partners, and that's a much more significant drop. And you begin to see some differentiation in the market that indicates that there's something going on at those firms with the higher attrition rates that's pushing those people out. And hopefully what we'll begin to do is identify who are those firms at the top that are holding on to people longer, and what are they doing right, and what can they teach the firms at the bottom.
I'm Mark Sheff from Workforce Management Magazine, and I'm wondering if the problems that law firms are having in diversifying is symptomatic of larger people management issues in the law profession and at law firms. In other words, does law have an HR problem generally, or is this just a particular an anomaly?
You know, a law firm spends, and he's right, $160,000 for first-year associates at major law firms. Those guys make a lot of money, but they don't have a lot of time to spend it because you work long, long, long hours. You have to be insane to love that. And so it is difficult for law firms to keep white male associates happy. At least, though, the white male associates have a reason to believe that at the end of the day, nowadays 10 years, you will be a shareholder in the firm. So retention is a problem, but it's really a problem for people that look like me. If there's no one that looks like me, if I walk into a law firm as an associate, there's no one that looks like me who's going to help me and have a relationship with me so that I can survive, I'm not going to stay. It is a thankless job for the first year. You're doing a lot of document review unless you're very lucky. You're making a lot of money, but it's not a happy place. And law firms are working to do, I think, a better job to keep all of their associates happy. Why? Because they're paying so much money. And so there is an HR problem, just generally with large law firms, which is one of the reasons why people go to small law firms, because you can go home. You make a lot less money, but you can go home. You can have quality of life issues. So I think you've hit the nail right there on the head.
Chuck, as the member of the panel closest to legal education, why don't you tell the audience about the problem that you and GM Senior Counsel and any others in the legal profession, the civil rights community have been having with the ABA, U.S. Department of Education, and their proposal to set a minimum bar pass rate rule and the impact it will have on minority admissions unless that rule comes out recently.
John's my straight man.
It sounds like a setup to me.
John Britton is from the Lawyers Committee on Civil Rights, was actually the moderator at the Congressional Black Caucus annual legislative conference panel that I mentioned earlier. What's looming on the horizon is that the ABA section of legal education is proposing to implement a bar passage standard, which started out focused only on first-time bar passage rates, which, as I mentioned before, is a problem. Has evolved over time, and actually Chris Johnson from General Motors has been terrific, basically leading a small group of law school deans that have been trying to convince the Council of Legal Education, which makes these policy decisions, to set some more reasonable benchmarks. But more importantly, what we've been promoting is trying to have alternative outcome measures besides the bar exam. The bar exam measures one small part of a person's ability to be a lawyer, sort of the academic side. It doesn't measure the skills side, doesn't say how good of an advocate or a negotiator or a mediator or any of the other multifaceted skills that lawyers have to perform. It doesn't measure the ethical side at all. Although there is a multi-state professional responsibility exam, it's an exam. It doesn't measure the sort of the ethical character of the people who law schools are producing. So what we've tried to do is push the ABA towards an alternative, an approach in measuring law schools that doesn't look just at the bar exam. Unfortunately, right now, we haven't been successful. Right now, pending before the ABA is a proposal that would focus exclusively on bar passage rates and would not take into account a school's mission. Lots of schools have different missions about what they want to achieve. And right now, the standard that the ABA is considering does not include that, which we think is a major shortcoming of that proposal. And that's, to answer John's question directly,
what's the impact of the DOE, Department of Education, squeezing on the ABA?
Well, that's an interesting question because actually there have been mixed signals on that. Actually, Chris Johnson met with some folks at the ABA, at the Department of Education, who said you can have alternative outcome measures and you can have mission. So it's a difficult question as to where that pressure is coming from, whether it's coming from the Department of Ed or whether it's internal to the council, who have for many, many years believed in the LSAT and believed in first-time bar passage rates.
And the DOE, Department of Education, authorizes the ABA to accredit American law schools. And the ABA credits American law schools, and it sets the standards which law schools must meet for accreditation. That's the stick that the ABA has over law schools.
That's correct. If you don't know, ABA accreditation means your graduates can take the bar exam in any state in the country. And if you have that, you will get students. If you don't have that, you won't get students and the school won't survive. So it's a monopoly power situation, actually, where the ABA controls, really does control who gets into law school and what law schools will be allowed to operate.
And what's the role of the Education Council with respect to the DOE and ABA?
You got any more plans?
Okay, no. Once every 5 years, if you know anything about accreditation, not just in the law school world, but generally, every accreditor has to go before the Department of Education once every 5 years to get their accreditation authority renewed. So that's where the Department of Education comes in. The ABA is up for renewal by the Department of Education, and as we speak.
The absolute worst part of my job is cutting off a discussion. I am trying to be respectful of everyone's time, and unfortunately, the press club needs a room after this, so I have to hold people's feet to the fire. I hope if there's one take-home message is I want to thank the panelists for an invigorating discussion, but a discussion that clearly could go on for at least one or two more panels, let alone days, months, et cetera. So thank you so much for attending.